This act is called Specific Relief Act 1963. Okay. There was an old act called the same Specific Relief Act in 1877. This 1877 act was repealed, that is cancelled, and a new act was brought into force. This act, the new act, is called Act 47 of 1963. Major portion of the old act was replaced except by retaining only one section, that is present section 42. So section 42 is the same section and it is exact with the previous law, that is old act 1877. Okay. Now, what this Specific Relief Act says? This Specific Relief Act caption, we will just understand the caption. Low audible. 1 second.
Okay. How's the volume now? I hope it will be audible now. In the new act, thank you for the kind replying. Now, in the act, the caption of that and the naming of the act, in the act is Specific Relief Act. Okay, Specific Relief. Specifically, you can go to the court and ask for certain specific remedies, that is specific reliefs, certain specific prayers, and those prayers which can be specifically granted under this act will be granted by the court. See, you may not be able to understand what I say. Example, if you take the Contract Act, see, we had the Contract Act from the year 1872. This Contract Act is a comprehensive act. That is, this act deals with everything. Contract Act deals with everything. What Contract Act says? If there is a contract between two parties, that is, if there is some understanding between two parties, and if one of the party fails to do something what he has actually agreed to do, then we call it a breach. Correct? We call it a breach. That is what we call in full term is breach of contract. Okay. Whenever there is a breach, that is, if one party does not agree to do something or fails to do something or does something not in compliance with the contract, then we call it a breach of contract. Okay, fine. So, what is the remedy for breach of contract? The remedy for breach of contract under the Contract Act is only compensation. Correct? So, if somebody has agreed to do something and if he fails to do something, you can go to the court to point out that this party, B party, has failed to do as promised by him, and therefore I have suffered some loss, and please compensate me with the loss. Okay, that is the purport of the Contract Act. But in Specific Relief Act, most of the participants herein would have come across cases with respect to sale agreements, enforcement of sale agreements. Part 2 of the Specific Relief Act contains certain specific provisions to enforce a sale agreement. Sale agreement is a contract. So this is a suit based on a contract in the form of a sale agreement. Here, the court can compel the owner of the land to execute the sale deed. Do you now get it? See, in Contract Act, you cannot ask for execution of sale deed. The Contract Act only can give you the relief of damages. But when you invoke the Specific Relief Act, then the court can grant the relief what you wanted. Another example, if somebody has trespassed into your property, உங்க நிலத்துக்குள்ள வந்துட்டாங்கன்னா அவர் வந்து ஏதோ டேமேஜ் பண்ணிட்டு போயிட்டாரு, you can ask for damages in the Contract Act. The Specific Relief Act வரதுக்கு முன்னாடி நம்மளோட ரெமிடி என்னன்னு கேட்டீங்கன்னா காம்பன்சேஷன். எனக்கு இதே திருப்பி பண்ணித்தா ரெஸ்டோர் அப்படின்னு கேட்க முடியுமான்னா ஸ்பெசிபிக் ரிலீஃப் ஆக்ட்ல கேட்கலாம். புரியுதுங்களா? So that is why we needed a specific act to grant certain specific reliefs. இந்த கான்ட்ராக்ட் ஆக்ட்ல முதல்ல கிட்டத்தட்ட 266 செக்ஷன்ஸ் இருந்தது on compilation. But what happened? The Contract Act was divided into various segments, deleted some portions, and taken away to form a separate act. Example, Sale of Goods Act. Original Contract Act section 76 to 123 has now become a specific act called Sale of Goods Act. So movable objects க்கு specific relief வேணும் அப்படின்னா you have to invoke specific act called Sale of Goods Act. Another act, Partnership Act. Partnership Act. Partnership Act ங்கிறது original section 239 to 236. That was removed, and dispute between partners or dispute which can be raised by a partnership firm can be dealt under that act. Likewise, to grant certain specific relief, a specific act has been formed or established or constituted so that the parties can ask for certain specific reliefs. Okay. Now, when you see the preamble of the act, what it says? The preamble of the act says, an act to define and amend the law relating to certain kinds of specific relief. So, certain kinds of specific relief can be granted under that. What are all those specific reliefs? Those specific reliefs are: one, possession, recovery of possession, which may be for movable property or for an immovable property, anything for that matter. Two, for specific performance of contracts, that is enforcing the sale agreement. Three, for rectifications of an instrument. Some survey number has gone wrong in an instrument while you were preparing that document. Some disputes which you come to know only later after 10 years that something has happened, you can rectify that instrument. You can cancel a contract. If you have prepared a contract, you can cancel a contract. That you call it as rescission of contract. Cancellation of an instrument, that is sale deed, you can cancel it. Settlement deed, you can cancel it. All these specific reliefs are granted under that. Another form of relief is declaratory relief, and another form of relief is injunctory reliefs. See, all these reliefs can be specifically granted under this act. That is, one, as a matter of repetition, I will say it to you: one, for recovery of possession; two, for specific performance; three, for rectification of instrument; four, for rescission of a contract; five, for cancellation of an instrument; six, for declaratory reliefs; seven, for injunctions. So all these specific reliefs are dealt with under separate chapters put together under three parts. So part 1, part 2, part 3. In part 1 of the act, it only deals about certain preliminaries, that is definitions, what is the purport of the act, what is the extent of the act, how far it can reach. This is part 1 containing section 2 to 4. In part 2, it deals with specific reliefs. It deals with specific reliefs. That is, it deals with around 6 kinds of reliefs. That is possession, specific performance, rectification, recession, cancellation of instruments, and declaratory reliefs. So 6 type of specific reliefs are dealt under part 2 containing section 5 to 35. Okay, fine. Part 3. In part 3, it only deals with injunctions alone. This section, this part 3 deals with injunctions alone for around 8 to 9 sections. So section 36 to 44. It deals with temporary injunctions, permanent injunction, mandatory injunction. So with this preamble, I will go into the details of the act. Okay. Am I clear? Fine. If anything that you require, you please post it, but not queries, not questions now. If it is audible or if it is not audible, please inform me by way of messages. Now, section 2. First section is always naming the act. Yes, how we introduce ourselves before a person, before a stranger. The act introduces itself to be called as Specific Relief Act. That is section 1. In section 2, this act deals with a certain type of definitions. What are all those definitions? It deals with a definition called obligation. Section 2A, obligation. Second one is settlement. Third one, trust. 4 is trustee. And 5 generally. I will just detail you the 5 definitions under the act. The first definition is obligation. Section 2, subsection A, obligation. What do you mean by obligation? Obligation is nothing but a responsibility towards others. Am I right? See, you are driving a car. You have the responsibility to others not to hit him on the road. The moral responsibility. Legal responsibility, take the car on the left side of the road. It's a legal responsibility. Should not go in the no entry. There are legal responsibility. So every man owes a certain amount of obligation towards others. If a person breaches that obligation, then the affected party can go to court. So now what is obligation? I will just cite an example, then go into the definition. See, there is a neighboring land. Your adjacent landowner is committing some infringing your right. He is constructing some building. One of his floor protrudes over your property. His property comes into your property. He encroaches upon your property. Or somebody trespasses into your property and puts a hut. You can always ask him to vacate. So he is not bound to come inside your property, except authorized by law. So this is an obligation. So every duty enforceable by law is called obligation. For example, you are entering into a sale agreement. In sale agreement, there are certain set of promises by one party and another set of promises by another party. That is promisor and promisee. One person agrees to pay the money and another person agrees to give his property for a definite sum of money. So if a party has an obligation to pay the money and B party has an obligation to sell his land. So if there is a breach, then you can invoke this act saying that that person has failed in his obligation. That is section 2A. So obligation is an inclusive definition. You cannot give a specific meaning for it. It says, it commences with the word includes. Obligation includes every duty enforceable by law. So if any duty which can be enforceable by law, then it becomes an obligation. For example, if a person is agreeing to sell a land, you are entering into a contract with that person. Unfortunately, that person who wants to sell the land is a minor. So you enter into an agreement with that minor. Now, can you compel that minor saying that you have agreed with that to sell the property? Now you sell that property. Can you do it? But minor can avoid the contract. He has no obligation to comply with the contract because he is disabled to enter into a contract. So contract which can be enforceable by law, the agreement which should be enforceable by law alone becomes a contract. So obligation includes every duty enforceable by law. In that case, the minor has no obligation against you. Similarly, if there is a fraud or if there is a coercion in a contract, then the other party can always avoid that contract, saying that he has no obligation to perform that contract. That obligation is not enforceable by law if the court comes to the conclusion that there is coercion, that there is some fraud in the contract. So obligation means and includes, it is an inclusive, it includes every duty enforceable by law. This is section 2A. Now we will go to 2B. It deals with settlement. See, settlement is a definition only defined under the specific relief act. If you miss out to this section, you can see the same word settlement in the Stamp Act. But often even the Transfer of Property Act does not define the word settlement, but it says it deals with a chapter called gift. It is akin to settlement. It's akin to settlement. So it deals with a chapter called gift. In settlement, what do you do? A grandfather writes a settlement or gifts the properties to the grandson or a granddaughter. So what he does, he gives away the property to another. Why this definition is important is, if you want to cancel this document, then you must know what is settlement. Correct? Now, what happens in settlement? One owner divests his right in the property and gives his right or displaces his right and grants his right to another person. That is called settlement. What the definition says? The definition says settlement is an instrument. So it should be an instrument. It should be a deed, a registered deed. Settlement means instrument, but it does not include will. So you cannot call a settlement a will. So it does not include will. So settlement is an instrument where the destination or a devolution of successive interest in movable or immovable property is disposed of or agreed to be disposed of. So what it says, an interest, a devolution or destination of interest. So if a person having some interest in this property, it may be movable or it may be immovable. If he disposes it of, if he disposes his devolution of some successive interest in the property, then that is called settlement. This settlement can be given now itself or agreed to be disposed of. For example, the grandmother will say that I have given the property now, but I will give the possession later. So agreed to be disposed of later. That is also settlement. The other section is trust. Trust is nothing but what has been defined under the Trust Act. It is again nothing but an obligation attached to the ownership of the property. That is called a trust. An obligation attached to the ownership of the property. That is called a trust. And that includes obligation in the nature of trust. What we just see section 3 of the Trust Act. Then trustee. Trustee is nothing but the person who holds that property, holds the trust property is called the trustee. The other important definition is section 2E. Section 2E, what it says is, even while you read a specific relief act, then the Contract Act and Registration Act will be applicable. The Contract Act will be applicable. That is what it says. So section 2E, when you read a specific relief act, you must also be conversant with the Contract Act. That is what it says. The other provision is section 4. Section 4, with this we can complete part 1. Section 4. Section 4, what it deals is specific relief. It deals about something called a specific relief. What the specific relief means? That specific relief must be civil in nature. Enforceability of a right should be civil in nature and not for enforcing penal laws. So you cannot say, arrest him, he has not sold his property to me, in spite of the agreement. So if there is an agreement, he has agreed to sell the property to you, but still you cannot ask for arresting that person. Somebody has trespassed into your land. You can only ask for recovery of possession, but you cannot ask for a punishment to put him in jail. So the ambit of Specific Relief Act is only to grant relief such of a civil nature and not to enforce criminal law in the garb of specific relief. So this is the thing. Now, at the same time, when we see section 3 says that you cannot deprive any person of any relief other than specific performance, which may have under any contract. See, what does that mean is, if there is a contract, even if this contract is not with respect to specific performance, even then you can ask for a remedy under the Specific Relief Act. So contracts need not be curtailed, or it need not be restricted to specific performance contracts alone. Other contracts can also be enforced, is the purport of section 3. And section 3 also says the Registration Act is applicable. So whatever mentioned under the Registration Act will have a direct bearing on the Specific Relief Act. Suppose if you are asking for a relief of title, you wanted to declare that you are the owner of the property, but unfortunately your sale deed is not registered. Okay, so you have obtained a sale deed, an unregistered sale deed, with which you wanted to enforce your right, and that sale deed value is more than 100 rupees as provided under the Transfer of Property Act. So in that case, just because the sale deed is not registered, your right is also lost. That is what it says. So when the Registration Act, when it compels, section 17 of the Registration Act compels a registration. Section 54 of the Transfer of Property Act compels a registration for sale deed. So under section 3 of this act says that the Registration Act also will be applicable. Then wherever the Registration Act will have force, then that should be read with the part, that is Registration Act should be read along with the Specific Relief Act. So this is part 1. So in part 1, we have dealt with four definitions, section 1, 2, 3, 4. 1 contains the name of the act and the jurisdiction of the act. 2 contains certain definitions. Those definitions are obligation, settlement, trust, trustees, and the extent of the applicability of Contract Act. In section 3, we saw savings provisions. That is, savings provisions means it contains 2 parts. First part deals about enforcement of other contracts other than specific performance contracts. That is permissible. So you can also enforce certain other contracts apart from specific performance contracts. And second portion of section 3 deals with applicability of the Registration Act. So Registration Act is applicable. Section 4 deals with enforcement of the Act, that is applicability of the Specific Relief Act, only with respect to disputes of civil nature, and you cannot seek any relief in the nature of penal laws. So punishments cannot be asked against it. However, injustice you are put to, you cannot ask for any relief as that will be provided under IPC. So this is the purport of part 1 containing section 2 to 4. Now I will just brush you with part 2 and part 3. We have only 18 minutes to go. In that case, I will just touch upon what is part 2 and what is part 3. In our continuation session, we will go into each of those in detail. Okay. Now, part 2 deals with possession, contract, rectification, recession, cancellation, and declaration. I will just repeat it for you. Section 5 to 35 of this part 2 deals with possession. It deals with 6 types of reliefs. Possession is primary, one relief. 2, contractual obligation. See, now we have seen section 3 also. So section 3 read with certain other provisions like section 10. You can enforce a remedy as provided under the contract for specific performance. 3 is rectification of instruments. I have already stated that for correcting the survey number or correcting some name or correcting some value mentioned in the property or identifying the property or changing the description, like common mistakes arises in while registration is while mentioning the description of property in east, west, north, south. இந்த ரோடுக்கும் கிழக்கு அப்படின்னா east of that road, but by overside people will mention west of that road, மேற்குன்னு மாத்திடுவாங்க. These type of mistakes are common. In that case, we can go for a rectification of instrument. Recession of a contract. If you wanted to cancel that contract entered into between the parties, we can ask for recession of the contract. Next coming is cancellation and declaration. That we will do. In chapter 2, what we will be mainly dealing about is possession. What is possession? Possession is nothing but something you have control over it, either as a owner or as an agent. The degree of possession may vary. There are 3 degrees of possession. That is higher degree, middle level, and lower degree of possession. What does it mean? In higher degree of possession, you will be the owner itself. As a owner, you will be controlling that property. You are staying in your own property. That is highest degree. That is real own. He owns that property under document itself. Lesser degree, slightly a lesser degree of possession. What does that mean? You might have rented that property, correct? You are in physical possession of that property as a tenant, but you are not the real owner. You are entitled to enjoy that property as how the owner himself would enjoy. See, you pay the rent, you enjoy that property. That is a lesser degree of possession. Then the lowest degree is possession of an agent. Agent has a restrictive right. If he is authorized to sell, he can only sell. He cannot go and stay in that property. A broker cannot go and stay in that property, correct? He is the lowest degree of control. But he is only authorized to do certain thing. If he is authorized to mortgage that property, he cannot sell that property. So he can act only as per the dictates of the principle. In the Contract Act, there is a specific provision of contract that is called special contracts between the relationship of a principal and an agent. Specific contracts. We will be dealing with those type of contracts as and when required. If you see the Contract Act section 182 to 238, around 50 sections deals with the relationship of the principal and an agent. For simple, if we see who is an agent is a person who does some job for and on behalf of another, correct? He is a person who does job, or we can say he can represent somebody. In legal sense, we can say he creates a binding contract with the principal and a third party. He is an agent. So any act done by him is deemed to be done by the principal, and the third party is also liable. This understanding you can get it from section 182 of the Contract Act and not from the specific relief. So he has only a restrictive right in the property, than that we call it a lowest degree of possession. This possession can be of again three types. One person who is possessing, that is these 3 degrees. Thing that is possessed. What is the thing that you are possessing? House or a mobile phone or a bike or whatever it is. Thing that is you are attaching or you are relating it to what you possess. So person possessing can be a owner or a tenant or an agent or even a trespasser. Thing possessed is what he is possessing. And the third one is most important. He is not the owner, but he possesses something without any authority. That is person excluded from possession, adverse possession, ouster concept. See, somebody is the owner, but he comes and stays in the property for so long a period prescribed under law, and he now claims himself to be the title holder. But he is excluding the rightful owner from possession. So there we have to see 3 factors while we deal with possession. So possession means a state of owning things or having in one's hand or power. That is what AIR 1959 Supreme Court 577 says. So possession means state of owning things. Possession means state of owning or having in own hand or power. AIR 1959 Supreme Court 577. It also deals with these 3 factors, that is person possession, things possessed, and person excluding another one from rightful possession. That is called adverse possession. I will also tell something to you. We have 10 more minutes to go. I hope we will deal with possession and we will continue it later. While we deal with possession, you would have also come across a certain type of phrases like a rightful possession, wrongful possession, adverse possession, permissive possession, ouster. You would have come across these type of concepts. Now, what is possession? Possession is the one who holds a thing rightfully. That is possession. Okay, fine. This is what you are going to deal in section 5 of the Specific Relief Act. Section 5 of the Specific Relief Act says about recovery of immovable property as provided in CPC. This you call it as a suit based on title. And when you read section 5 and 6, section 5 and 6 deals with possession relating to immovable properties. Section 7 and 8 deals with possession or recovery of possession with respect to movable properties. So these 4 sections, 5, 6, 7, 8, I will just explain it and we will complete the session today. 5, 6, 7, 8 அதான் possession அப்படிங்கிறதுக்கு 5, 6, 7, 8 தான் நம்ம பார்க்கணும். Movable இருந்தா we have to relate ourselves to section 5. Immovable means we have to see section 6. Okay. Now, what is section 5? Section 5 says recovery of immovable property. And another thing, it also says a person entitled to possession, a person entitled to possession of specific immovable property may recover it as per CPC. That is what they say. It is a very, very simple definition with only 2 lines. It says a person entitled to, see, entitled to, most important word, person entitled to possession of specific immovable property. 2. One is person entitled, then specific immovable property, things, person, things. He may recover it. It only says about 3 things. One is person entitled may recover. 1. 2. What he can recover? Specific immovable property. The second point. Then 3rd, what he can do? He can recover it. So person entitled, specific immovable property, recover. Recovery can be done as per CPC. So you can, as usual, file a plaint and get it done. But what we have to see is the difference between section 5 and 6. Section 5 deals with possession, recovery of possession of a specific property on the basis of title. That is, if you have sale deed, you can ask for possession of the property. If you don't have a sale deed and if you don't have a right at all, then you cannot ask for possession. So what it says person entitled. How you will be entitled? Either by purchase you can be entitled, either by inheritance you will be entitled, by will you can be entitled, or as an agent you will be entitled to the principal authorizing you to go and recover the property. Only on some specific grounds you can invoke this provision. What is the limitation period for invoking this provision? It is 12 years. It is 12 years. This is section 5. What is section 6? Section 6 is a slight variation from section 5. Section 6 says suit on previous possession. See, section 5 says suit on possession, suit for on title. Section 6 says suit on previous possession. What does that mean? In previous possession means a tenant. If a tenant is evicted suddenly, if a tenant is evicted forcibly by the landlord, then the tenant, with the help of the lease deed, he can go to the court saying, see, my lease period itself is not over. I am put in possession by the landlord. I am a tenant. I am a lessee there. But the landlord has forcibly dispossessed me. And therefore, he can go to the court and ask for a specific relief of possession. But there is some limitation under that. he must have to go to the court within a period of 6 months. So law of limitation prescribed as 6 months. It is inbuilt in this section itself. You cannot go and search under the Limitation Act. Okay, should not go and search under the Limitation Act. You have to see here only section 6. And again there is an embargo. What it says, you cannot file a case against a government on suppose you were in occupation of a Porambok property. Porambok property practically belongs to the government, but government has control over it. Now government evicts you. You cannot go to the court and say, I was in previous possession in a Porambok land. I have come before within 6 months' time. Please restore me. That cannot be done. So one is, if you have a lawful possession, within 6 months, you can go and ask for it. 2, not against the government. 3, limitation period. Suppose if you have missed out the limitation period, what is the remedy? If you go on the 7th month or 8th month, you can still file a case. You can still file a case and establish your title or your better title to the property. Somebody would have got assignment. He has a better title than the person who has a mere chit or a mortgage. So, or some record to show his possession. So these are all the things that we must have to see the difference between section 5 and section 6 of the specific relief. So section 5 deals with suit on title. Section 6 deals with suit on previous possession. Section 7 and 8 are similar to section 5 and 6. But it deals with movable properties. It says about the same thing, person entitled to movable property. In section 5, it says person entitled to immovable property. In section 7, it says person entitled to movable property. So it need not be a owner. It need not be a title holder. If he is entitled, suppose you have borrowed your friend's laptop, somebody has taken it. Still, you can go to the court saying that my friend has gone to America. He has given the laptop to me, but that fellow has taken it. That is sufficient. You can show it by means of an authorization and go for a suit for recovery of possession of movable property. And section 8 is also like that. That is, the trustee should not misuse that property and of the like nature. So with this, we will conclude today's session. I will just sum up to you in another 1 or 2 minutes. I will not take much of your time. I am very conscious of it. So Specific Relief Act is an act for certain specific reliefs. Point number 1, you cannot ask for general reliefs as provided under the Contract Act. There is a distinction between the relief granted under the Contract Act and the relief granted under the Specific Relief Act. In Contract Act, you can only sue for breach and ask for compensation. But in the Specific Relief Act, you can ask for certain types of specific reliefs. Certain types of specific reliefs are possession, specific performance, rectification, recession, cancellation, declaratory reliefs, and injunction. These type of 7 types of reliefs can be asked in the Specific Relief Act. Then we saw about part 1 exclusively. In part 1, we dealt with section 2 to 4. Section 2 contained certain definitions. It contained about obligation, it contained about settlement, trust, trustee, and the applicability of the Contract Act. Obligation is nothing but every duty enforceable by law. Settlement means a person who has a right in a property, he dispossesses his right, or devolves of successive interest if he has, and he gives it to somebody, or he agrees to give it to somebody, is called settlement. Trust, as per section 3 of the Trust Act, that is, it is nothing but obligation attached to the ownership of the trust property. Trustee, person who holds the trust, is called the trustee. And the Contract Act applies to Specific Relief Act. And in section 3, we saw 2 things. 1, you can also enforce a certain type of contracts apart from the contracts of specific relief. This is one segment. Second segment, it said Indian Registration Act will apply wherever it is necessary. These are all the two things that we saw in section 4. Section 3. In section 4, we saw that the Specific Relief Act is applicable only for enforcing certain civil rights and not for penal laws. You cannot ask for punishments. That is not possible. With this, we completed part 1 of the Specific Relief Act. In part 2, we dealt with section 5, 6, 7, and 8 of the Specific Relief Act. It dealt with possessions alone. Possessions, it can be movable property, it can be immovable property. In immovable property, we dealt with section 5 and 6. We saw section 5 and 6. Section 5 is with respect to recovery of immovable property on the basis of title. Section 6 is recovery of immovable property on the basis of previous possession, like termination of lease or whatever it is, forcible eviction. In section 7 and section 8, we dealt with the recovery of movable properties. And those who have the movable property, what is the liability of those who have movable properties is what we have seen up till now.